I would like to now turn to Her Honour Judge Sapnara, who is a Deputy High Court judge in England and has made several decisions in family cases, some lots of reported decisions, some which were very hotly debated in the press, and very difficult and sensitive decisions. We know that England is a rich country compared to Pakistan. There are a lot more resources for the state to protect children, to give children a voice in proceedings, to give them separate legal representation, to assign a social worker to children, and to represent their views in a sort of more cohesive and sensitive way. What would you say in terms of representing the voice of children and the welfare of children? How would you say that in England things would be done, a judge would approach a child's voice in proceedings? What would be the guidelines for that?
What is important to emphasize is that the child is an individual. And as an individual, a child is very important. The child, at the end of the day, is the subject of proceedings. And therefore what we do is apply the principle of best interests of the child. The welfare of the child in a lot of decisions is paramount consideration, and we look to the specific issues relating to the specific child, even if the child has other siblings and there are common threads in respect of their case. It's the individual child and the needs of the individual child, and to need to protect the rights and promote the welfare of the child that is really our priority in our jurisdiction. And this notion and principle of the child as an individual is something that needs to be respected. It is entitled, a child is entitled to that dignity and to have their rights respected and upheld. They are central to the proceedings and not subsidiary. And I think a speaker in the main hall earlier referred to the idea that children should know their rights very early on in life, because it's only then that later on you can claim them and seek to have them given effect in difficulties that are experienced in perhaps later life. And that is actually, it seems to me, very important because the decisions we make are ones that are very serious and profoundly impact upon a child, not just in the immediate aftermath of our decision, but they have long-term, very pronounced consequences for a child. And so in certain proceedings, we look at not just the welfare, short, medium, and long-term, but throughout the child's life. There are various rights that children are entitled to, and sometimes they conflict with other rights. And so in terms of protecting children, if a child has made allegations of abuse, it may be that the child is required to give evidence. We have a range of criteria that we have to apply in law in determining whether or not the child should have to give evidence. And if the child doesn't give evidence, and if they're of sufficient age and understanding in order to be able to participate in the proceedings, then that potentially compromises the Article 6 rights pursuant to the European Convention on Human Rights of the parents to a fair trial. But similarly, we need equality of arms. And so if a child is a party to proceedings, then we look to see that the child should have not just a voice, but actual representation. And that's where, as a wealthier nation, I recognize the difficulties and the financial constraints in a jurisdiction like Pakistan in establishing a mode where in our adversarial system a child has what we call a tandem model, which has been referred to in case law by judges in the past as being like a Rolls-Royce service level that is the envy of the world. And so in certain proceedings, the child is not only participating, but they are represented by lawyers. They're entitled to the best lawyers in the country, and the funding is met by the state through legal aid. So there are numerous ways in which the child might be able to participate. One of the ways we have is a body that is established called CAFCAS. Essentially, these are experienced welfare officers, often with a social work background. They have a reporting duty. They also have some investigative powers. And so we have two forms of proceedings. One is private law, which is between usually parents, but maybe other members of the family relating to the child. And the other is where the state intervenes, where there is risk of harm or harm suffered by a child. And that may well be very serious physical abuse. Sometimes a sibling has died as a result of injuries, or a child has suffered catastrophic injuries in the care of a parent, and also including very serious sexual abuse of very young children sometimes, within a context sometimes of intergenerational sexual abuse. And I have to tell you that a lot of the cases that come before the court, they're not just confined to the majority community. There are lots of families from a minority ethnic background for English purposes, who are from a Bangladeshi, Pakistani, Indian background, where these issues are really very live. So in terms of the proceedings relating to children, we drew together the various international declarations and covenants in respect of human rights, taking into account the importance of the traditions and cultural values of each people for the protection and harmonious development of the child, and the importance of international cooperation for improving the living condition of every child in the country. And that led to the United Nations Convention on the Rights of the Child in 1989. That is regarded as the most comprehensive statement of children's rights ever produced, and the most widely ratified international human rights treaty in history. It has even been accepted by non-state entities, such as the Sudan People's Liberation Army, which is a rebel movement in South Sudan. And what that did was establish this transformative idea that children are not the property of their parents, about whom decisions are simply made by adults, but that this distinct time spent as a child, and a child is defined as a person under the age of 18, is a special protected time in which they have fundamental rights and must be allowed their own dignity. It sets standards for education, healthcare, social services, penal laws, and establishes the right of children to have a say in decisions that affect them. And so I've spoken a little bit about we also are signatories to the European Convention on Human Rights, which was incorporated into domestic law in the UK in the Human Rights Act 1998, which came into force in October 2000. And the rights in the ECHR include the right to life, the right to be kept safe from torture and cruel treatment, freedom from slavery, the right to a fair trial, and the right to respect for private and family life, as well as the right to an education. So the way that we hear children's voices within the proceedings very often is through the vehicle of a welfare officer. That can come from the organisation CAFCAS or from the state at local government level in the area in which the child is living, who may have quite extensive knowledge about the children's circumstances and their families. And we have a multidisciplinary approach to determining issues relating to children, which includes the involvement of a number of experts and professionals who undertake assessments to help the judge better understand what the needs of the child are, what the risks are to their welfare and how those risks can be managed. And in order to manage the risks, there is a sort of presumption that a child is best brought up in its biological family, if at all possible, and if commensurate with the child's welfare. And the child's welfare and best interests is an overarching concept in terms of the decisions that we make. And so there's been quite a lot of development of many laws in the UK which aim to keep children safe and to protect their rights. And one of the ones that I've been very closely involved in is the Forced Marriage Act, which seeks to protect children and any individual, including adults, because we recognise how vulnerable some adults are, to protection in that regard. So best interests, very important. We have to have regard to a range of factors when we decide the best interest of a child, and that includes the ascertainable wishes and feelings of the child concerned, which is to be considered in the light of his age and understanding. And we look at the physical, emotional, educational needs, the likely effect on the child of any change in circumstances. The child's age, sex, background is important, and that includes cultural and religious considerations as well, and obviously any harm that the child has suffered or is at risk of suffering. And we look to see how capable each of his parents is, and any other person in relation to whom the court considers the question to be relevant to meeting his needs. I'm referring all the time to he. That's how the statute is drafted. I would prefer, actually, when I talk about a child, to talk about she, because actually, when you look at the family unit and the dynamics of society, the girl child, the power imbalances for a girl child are often really profound, and they are far more extensive than those that impact on boys, because, you know, to an extent we all have notions of patriarchal values embedded in the laws that are enacted. So the voice of the child, as I say, is rooted in the various international declarations in respects of the right of the child. In England, we have traditionally approached things in quite a paternalistic way, but the law has evolved where we are looking to see how we can accommodate children in terms of their active participation in actually listening to their views and wishes and feelings. And there are various ways in which that is done. One is, as I've said, through these officers appointed by the court. Sometimes a child wants to sit in during a hearing in order to hear what is being said and done about them. That is quite a difficult, problematic area, because the process of sitting in and listening to some of this evidence can in itself be harmful to the child. So that's where the maturity of the child, the competence of the child to participate is what we take into account. And there's quite a lot of law around how you assess a child's competence and ability to give instructions. Sometimes, if the child's views are in conflict with the reporting officer's view, then we don't take a paternalistic attitude. The child is entitled, in certain circumstances, then, to separate representation so that the child's voice is heard. So sometimes I might join a child to proceedings so that they are active participants. In other cases, even though they're the subject, usually in private law cases, they don't tend to be separately represented unless it's absolutely necessary. And that is all about really resources and appropriate allocation of resources. Sometimes the children want to visit court to meet with me as the judge, and they are entitled to do that. Sometimes it is not enough for them that I simply hear from third parties their views, and they come to court. And these days what we do is record the session with the child. The child comes along, is often prepared in advance, because it can be quite daunting to meet a judge. I mean, when I was a very junior barrister, it was quite daunting meeting the judge in that context. And the child, with all their vulnerabilities, not just because they are young, but sometimes that is compounded grounded because they may have language difficulties, mental health difficulties, learning disability, and so we have ways of making them heard, and sometimes we might have an expert intermediary who is an expert in communication skills to get the message across. And that meeting, as I say, is recorded. We have to be open and tell the child it's transparent proceedings and that their parents will be informed about what they say. That in itself is sometimes inhibiting for a child. But very often, especially older children, want to come and they want to be heard. And as I say, increasingly in cases, children are being called as witnesses to give evidence. We have a lot of safeguards in place for that, first of all, in assessing whether they should come and give evidence. And usually there is an expert assessment of the harm that it might cause them in coming and being that actively involved, especially in circumstances where there is a lot of other evidence sometimes that is available to us without having to hear the child then and there. They might have made complaints to teachers, to social workers, to the police. There may be a pre-recorded interview with them, which is called an Achieving Best Evidence interview. That has evidential value. And so sometimes it's not necessary. But if it is, and it all depends on a range of factors as to whether they will be called, sometimes we will make sure that the questions to be posed are scrutinized by the judge, submitted to me in advance, and that they are appropriately phrased, short, child-friendly language that can be understood, and the questions will not be put in a hostile fashion. So sometimes the judge will pose the questions, or the child's solicitor will pose those questions, even though they form the cross-examination on behalf of other parties. And one last thing I just wanted to touch upon, because this goes to the heart of what I was saying earlier about the tensions and the conflicts between various international human rights. One of the main issues in our courts at the moment is the right of the press to freely attend hearings and report on the proceedings, and we are in the middle of giving effect to some policies that have arisen out of extensive consultations, including with children's groups, and the children overwhelmingly are against publication of information that will be available in the public domain online for very many years to come. And so there is very fine balancing exercise. At the end of the day, there is a residual judicial discretion in relation to all of this, because you can imagine that is problematic. On the other hand, we have to have open justice and transparency, and there has been charges leveled against the family courts about the freedom of the press in being able to report. So now really the emphasis, yes, press are going to be allowed in, not individuals in society, press to be allowed in. They can report, but the child's identity must remain anonymous. And that is problematic because there's lots of information in judgments, which if you piece them together in a jigsaw fashion, leads to the identity of the child being known, particularly in small minority communities who have lines of communication, the length and breadth of the jurisdiction, and all you have to say perhaps is that this is a child who is aged, let's say, 14. She has 3 siblings, they're brothers. Their parents are divorced and the mother remarried. And you don't even have to say the area before people start knowing and are able to identify. And they're the sort of things we have to guard against. There are real risks to the child, but that's the tension that we are trying to reconcile those competing rights. So I'm going to stop there.